Lawyers need experts. Regardless of the subject in which you may offer legal support, the need for expert witnesses spans subjects from A to Z. Internet resources list over 500 categories and thousands of subcategories, ranging from abuse to zoning, with your specialty probably falling somewhere in the list. Lawyers use experts in litigation from medical malpractice to engineering to accounting to the ubiquitous field of computing. You can see a list of principal consulting categories in the Registry of Experts at expert-witnesses.net. As an expert witness, you must bring to the table pre-existing expertise that includes detailed knowledge of your subject. You may have already published books, articles, or journal treatises. You may already consult independently, or you may work for a company as a specialist who has the freedom to work independently as well. If you also bring the skill of communication, you can help the litigants reach an out-of-court settlement. The basic question about your qualifications remains. Can you legitimately present yourself to attorneys as a possible expert witness? Now, you may ask why lawyers may need you for this kind of work. Attorneys know the law, but rarely know your specialty as well as you. Since they cannot testify about it, even if they do understand the field, they have to hire experts like you. They also do not have the time to do the research and analysis to obtain the technical nitty-gritty about the case. So they hire you to spend your time doing that. You know how to do the research and the follow-on analyses. When litigants dispute the same evidence and either side might win the case, then you can testify about the results. A defense attorney has to do their best job to either prove innocence or play the game well enough to obtain an innocent verdict for their client. The expert witness must present the technical evidence in the best possible light. At the same time, you may have your own doubts about the strength of the evidence, and you may see the reasonableness of the other side's evidence. That can be difficult for you. You must present and explain the helpful evidence as well as possible, and leave the so-called harmful evidence to the other expert. The other expert has to present the harmful information as well as they can. What evidence you should present during testimony can become an ethical quandary. Sometimes you will realize that the person whose side has hired you may have committed the alleged crime. An important tactic for you to consider, then, is that you can contribute to each case by providing your attorney with analyses of the facts, no matter whether your findings seem helpful or not. Let the attorney decide for his client whether to proceed with the case or attempt to settle for a better possible result. The majority of legal disputes never reach the stage of a trial. Once everyone discovers the facts, and the experts complete the technical analyses, and the lawyers take the depositions, the outcome usually becomes evident. The parties can use your work as an expert as the basis for an eventual settlement. Sometimes, attorneys will hire you as an expert to provide them with these analyses before they even file a lawsuit. Your objective interpretation of the information can sometimes convince the attorney to not even file the lawsuit. In the same fashion, even after filing a lawsuit, plaintiffs may sometimes drop a case if an expert's analysis shows that they will definitely lose. When an expert for the defense shows why their side will lose, that is when talks for the best settlement or plea bargain begin. As a plaintiff's expert, you may find information that actually sustains the prosecution's allegations. At the same time, you may also find exculpatory evidence that helps to reduce or negate the plaintiff's charges. The defense can use this additional information to support arguments in court against conviction. Your information may not lead directly to an innocent verdict, but it may lead to a better settlement. Ethical quandaries can emerge for you when presenting exculpatory evidence for the defense or weak evidence for the plaintiff. If you wish to avoid these difficulties, you will simply have to choose your cases differently.